I'm Anjanette Levy, and thanks for joining us here on this Wednesday afternoon for our lunchtime Q&A session on the YNW Melly double murder trial. We have been at it for weeks now, and closing arguments will be held tomorrow. Court is dark today. Both sides rested their cases yesterday. And now the only thing between 24-year-old Jamell Demons and the death penalty, the possibility of it, is closing arguments and a guilty verdict. So we will be keeping a close eye on this for you throughout the remainder of the trial to see whether or not that jury decides that the state has proven its case or not. So we will keep a close eye on it for you. We're going to hear closing arguments, as I mentioned, tomorrow morning. And of course, this is the case where Melly is on trial for the 2018 shooting deaths of his two friends, Anthony Williams and Christopher Thomas Jr. The victims were on their way back from a recording session with Melly and his co-defendant, Cortlen Henry, on the day in question. Demons and Henry claim that they are innocent, saying that they were caught up in a drive-by shooting. But according to the prosecution, evidence suggests the shots were fired from inside the vehicle. The state took 15 days to present its case against Melly, whereas the defense wrapped their case in just one day by calling one witness. I have a great panel with us this afternoon to take all of your questions, so keep those coming to us on YouTube, Twitter, Facebook, Instagram, Twitter, Threads and Instagram. I messed up one of those. We'll get to as many of them as we can, and we have a great panel with us today. Terry Austin of Law&Crime is down there at the Broward County Courthouse covering the case for us. Michael Bryant is a host here at Law&Crime and also an attorney, and criminal defense attorney Natalie Whittingham-Burrell is with us as well. Terry, I'm going to start with you. All quiet, the calm before the storm on this Wednesday.
That's a great way of putting it. It is all quiet here in the courtroom. No one is there. They may be back today to have arguments. The jury will not be there, but we will see defense counsel and the prosecution if, in fact, they cannot agree to these jury charges. Defense is supposed to let the prosecution know and let the judge know whether or not everything has been ironed out. They did resolve the issues for most of those charges. There was a issue as far as premeditated was concerned. The judge basically said the defense objection was overruled and they are using the standard. There was an issue for a gang charge. The defense wanted it to have additional wording. The judge overruled that. The one issue that has not been resolved is whether or not there is a felony murder count. Felony murder, if you recall, is when there is another felony in the commission of the murder at the same time. And the whole point that the defense is trying to argue here is, look, the medical examiner did not even state whether or not one of the victims died before the other. So you can't have that felony murder charge. The prosecution disagreed. Anjanette, you may recall that there were felony murder charges in the Parkland shooter case, and so the issue is whether or not that will be allowed here. We will find that out today. The jury will be back tomorrow. They will hear the closings, as you mentioned. They will hear the jury charges, and then they are expected to deliberate as soon as that's concluded.
Terry, I want to make sure I have this straight here, and I'm wondering, what would the underlying felony be if that's a requirement for the felony murder charge in this case? I don't understand. I don't know. Would it be kidnapping? I mean, wouldn't that have to be as part of the indictment? I don't get it.
The underlying murder, and that's exactly what the defense is arguing, Anjanette, would be the killing of the first victim and then the killing of the second victim. So the second victim would have been killed in connection with the commission of the first crime of the first victim. And what the defense is arguing is that doesn't make sense. And here we don't even know which of the victims died first. That was what was determined factually on the stand. The medical examiner nor anyone else was able to determine who died first, just that they were shot and that the fatal shots, according to the prosecution, came from inside that car. So it's a big issue whether or not they're going to add that felony murder count. It would be based on the evidence that was seen and what the defense is saying. There was no evidence to that effect, and the judge is reading all of the case law in connection with this, and he said he will have a decision today.
I wonder if felony murder is death penalty eligible. Maybe it's not. I would think it would only be first degree murder that would be.
Yeah, I don't think it is death penalty eligible. I think already because they have the death penalty on the table already, it's sort of a moot point. And Jeanette, even if it were death penalty eligible, and let me just state something else. The judge did say he was going to try to have his decision, I think, last night. Either way, it should be resolved today by 1.
Mm-hmm. I will be interested to see what comes of that. All right. As I mentioned, we are taking your questions, so keep them coming to us on YouTube, Twitter, Facebook, Instagram, Threads, and TikTok, and we'll get to as many of them as we can. Let's get to the first question here. This one will be for you, Michael Bryant. Does Bortlen have an upcoming trial, and will Melly be subpoenaed to testify? This is from Brianna Lynn from YouTube.
It's very interesting, the subpoena part. We know the trial is, in theory, going to take place in October. The question is, depending on the outcome of this trial, would Melly even take the stand, or would he take the fifth? Obviously, if he's acquitted in this case, maybe more likely he'd take the stand. If he is convicted, I don't know, maybe he'd take the stand too. There's nothing more that he might claim the fifth to protect, and he may have some very interesting insights on who is now his co-defendant or defendant in the case to come. Very interesting. We won't know for sure until this case is resolved. Let's not get ahead of ourselves here. Once this case is resolved, then the Cortlen Henry picture will definitely start to get clearer.
Mm-hmm, most certainly. And we're nearing the finish line here, at least with this part of the case. Obviously, there will not be a sentencing phase if Melly is not convicted, if he's found not guilty. Leisha Betru from YouTube. This one will go to you, Natalie. Do the attorneys on the panel believe the state has presented a case to convict Melly of double murder beyond a reasonable doubt to face the death penalty?
Well, I'll give my perspective as a criminal defense attorney. I think that they have laid a case. This is not the penalty phase. This is the guilt or innocence phase. I think that they have laid a case at this stage beyond a reasonable doubt for murder as to both of the victims in the case. And the reason that I think that is because they showed that Melly was at the location. Now, beyond a reasonable doubt, that's up to the jury. But I think this is just my opinion. He was at the location in the vehicle. He was in the position that he would have needed to be in order to be the shooter. And then he texted someone saying, "I did that." And I feel like when you tell a jury not to put their common sense aside, common sense would dictate that he's the person who did it. The defense has some things to argue and to play with there, but I think that the prosecution has laid a case.
Very interesting, Natalie. Great perspective. Since you are a criminal defense attorney, you know how this works. Were you surprised, and this is just my follow-up question to you, Natalie, that the defense only called one witness? We had expected to possibly hear from an expert-type witness. And if you were surprised, were you surprised that it was Adrian Davis?
Well, I was surprised that it was Adrian Davis, but the reason I was surprised is because I was on here with Michelle, and I said, well, there's no way they have an alibi witness. And they actually had an alibi witness, someone who sat there and said that YNW Melly was not with his phone, that he was not in the car at the time of the shooting, that they found out about the shooting at the same time as each other. That's completely risky. I would hope that there's no negative consequences to this gentleman in the future if Mr. Demons is found to be guilty. Them only calling him as a witness, though, I think was very good defense strategy, because they have someone to say the words out loud. Mr. Demons was not there. YNW Melly was not there. And I don't think it would have helped them to call the phone expert, because they're conceding that his phone was at the scene. So they don't need to question that expert. And it seems like they wouldn't have had a crime scene reconstructionist who would have said that the victims were shot in a drive-by shooting. So if you don't have the evidence, you just can't present what you don't have. They kept it tight, and I thought that was a good idea.
Very interesting, Natalie. Interesting perspective there. Just Chillin' here. I think we've heard from Just Chillin' here before too, Terry, from Twitter. Also, if acquitted, could the prosecution change Cortland's indictment from accessory to actual first-degree murder?
Well, Just Chillin', I definitely think the prosecution could change the indictment to anything they want to based on what this jury states as far as YNW Melly is concerned. They are going to have to change their theory. Let's assume, as you've asked, that he is acquitted. If he's acquitted, they have to figure out who the shooter is. So if they determine that they think the shooter then at that point could have been Bortlen, then they will have to have some sort of theory. They will have to look at what the charges are. They could go up or down. They could say, look, we don't have anyone else who's the shooter. We can go up. We can say that this is a death penalty case. They can, they give notice to the other side and totally change their strategy, or they could go down. Or, and I do think this is a distinct possibility, I think they could approach each other and perhaps they could hash out a plea bargain at that point. So anything is possible if there's an acquittal, and frankly, anything is possible if there is a conviction. I think the prosecution at that point would be free to negotiate something else or to change their theory at the trial that's upcoming for Cortlen Henry.
Mm-hmm. We have another question from @JustChillin here, Michael, and I'll send this one over to you. If Melly should be found not guilty, could Cortland's lawyers still try to pin the crime on Melly like Melly's lawyers tried to pin on Cortland? And if so, would that strategy then even still be advisable?
Yeah, actually, I think it's a better argument. And just chillin', you're really writing a lot of questions for somebody who's just chillin'. But, if
there's another one, too.
If you look at the shooter reconstruction information, it looks like all the shots were fired, if you believe the guy, from the back seat. Well, I don't think there's any dispute that Cortlen Bortlen was in the front seat. So it makes it harder for Melly to point the finger at Mr. Henry, but it makes it easier for Mr. Henry to point the finger at Mr. Demons, assuming he was in the car. We know we have conflicting stories about that, but we don't have a lot of conflicting information about the trajectory of the bullets. So unless you're sitting in that driver's seat and you reach back and you're shooting, backwards across your body, the trajectory doesn't make any sense. So I think it's a better argument that Demons can say no, that Cortland can say no, Demons did it. I was in the wrong seat. The evidence doesn't match.
And I wonder, too, if he could then get up on the stand, Michael, you've got me thinking here, and he could get up on the stand and say, I freaked out and lied, he did it, and I was just under duress. Yeah,
I think there's a lot of interplay between these guys, kind of this, honor among thieves, as it were, and I don't think anybody's going to be ratting anybody else out. I just don't think that's the way they operate.
Interesting. Yeah, there's that no snitch culture. I remember that from when I worked in local news covering a lot of homicide cases. It was a big problem in prosecuting cases. People didn't want to be labeled a snitch. All right, let's get to more questions after this break. Keep them coming to us on YouTube, Twitter, Facebook, Instagram, TikTok, and Threads. We'll get to as many of them as we can. Stay with us. I'm Anjanette Levy. You are watching Law and Crime. We'll be right back. I'm Anjanette Levy, and thanks for joining us here on Law and Crime as we answer your questions during our lunchtime Q&A session on the YNW Melly double murder trial. We have tons of questions coming in, even though court is dark today. Closing arguments are set for tomorrow, and we will have those covered for you. So tune in bright and early here to the Law and Crime Network, both here on the air and then on our YouTube channel. We have a lot of great questions coming in. We'll get right to it. Charles Thorpe from YouTube asks, why didn't Melly have any other witnesses? And why didn't he go on the stand for himself? I know if it was my life, I'd be on that stand for sure to clear my name. And Natalie, I'll throw that one over to you.
I'll take that backwards. The reason he didn't get on the stand is because it would not have been helpful to him. What would he have gotten on the stand to say? I wasn't there. I didn't do it. Well, they already had a witness to say that. And there are impeachable offenses in Melly's past that they may be able to use in order to say he's not telling the truth that may make him look like he's guilty because of his criminal record. There's statements he's made in the past that they may be able to use against him that may make him look like he's not telling the truth or make him look like he's a violent person. There was just way too much risk involved. And he has a constitutional right not to testify and to remain silent. And the jury is going to be told about that they cannot hold that against him. And the reason they didn't call more witnesses is because strategically speaking, all they needed was someone to say that it wasn't Melly and he wasn't there. And also practically speaking, I don't think the defense had anything more than someone saying that it was not Melly and he was not there. Remember, it's not their burden to prove that he's not guilty. It's just simply their burden to protect their client. And that's what they did in this trial.
Very good perspective there, Natalie. Ruthra D. Zawil from Instagram. So then just went over to you, Terry. When's it going to be over? It seems to be going on forever.
That's an excellent question. It has been going on forever. This is the fifth week, I believe. They had a dark week for the week of July 4th, but the prosecution's case was fairly long. We saw that the defense case was relatively short, which is something I think that is common because, as Natalie correctly pointed out, the defense does not have to put on a case at all, and the jury is going to be charged that Melly does not have to get on that stand. He has the right not to testify. So I think now we are finally at a point where it is wrapping up. We know for a fact that the closing arguments and the jury charges will be done tomorrow. What we don't know is how long will it take that jury to deliberate. They will start their deliberations as soon as the charges and closings are completed. That may be Thursday evening, it could be Friday morning, and they could come to some sort of conclusion by the end of Friday. If not, they will be sequestered over the weekend and they'll begin deliberating again on Monday. So it's not over yet, but we are close to the finish line and we can basically see the light at the end of that tunnel.
Yeah, if they do have to go through the weekend, I hope they have plenty of things to do at the hotel because they will be sequestered and hopefully a swimming pool. It's hot down there. Kai Dollar Signs from Instagram, Michael Bryant asks, if Melly didn't do it, then who did?
Boy, that's a good question. You know, I guess you could suggest Cortlen Henry did it. The guy is going to be tried in October for basically the same crimes. Yeah, it could be the drive-by shooters. Remember, that's the theory of the defense in this case. It wasn't Melly. He wasn't in the car. It was somebody just doing a drive-by because he had a lot of enemies. So if the prosecution does not prove to this jury that it was Jamell Demons, then, there aren't a whole lot of likely suspects identified.
Natalie, Darius Sanchez-Smith from Facebook asks, if Melly and Bortlen had the only keys to Melly's house, how did the people in the red Mitsubishi get into Melly's place? And if so, shouldn't the gate guard have been a witness?
Oh, shouldn't the gate guard have been a witness? That's a really, really good question. Might have been a good person for the defense to call, but they did not. And so you can only guess that either that person wasn't there, they didn't have the opportunity to observe, or they wouldn't have said something that was helpful, or they refused to come in. There's really no way to know that. But that does help the defense, story that, only Bortlen and YNW Melly had keys to the house. But that's assuming a lot of things, that that witness was telling the truth. It's also assuming that the door wasn't somehow unlocked. They didn't have some other way to get in. There wasn't a grounds person or someone else in the house to let them in. It assumes a lot. So it's up to the jury whether or not they believe that witness. And I don't know if they're going to. That's why juries are so important, because they get to make that decision all to themselves.
I do want to point out, too, that the jury saw a snippet of video from the guard shack or from that entrance gate to the complex as well. So it showed the driver and then some other people in that red Mitsubishi. So I would love to go back and take a closer look at that to see just how many, how closely you could see into the vehicle. But it was just for a short time they showed that. Let's see. Let's get to this next question. Garcia Karen from Facebook, Terry, asks, what if he's found guilty, but later with Bortlen's trial, we find out it was, after all, Bortlen?
Well, he will be set free if he's found guilty, and he cannot be charged again if he is found not guilty. There's something called, double jeopardy, and once a jury acquits a defendant for any charges, but especially as far as this murder charge is concerned, he cannot be charged with that again, no matter what happens in the next trial as far as Henry is concerned. So that trial, could go forward with the same charges against Henry. It could go forward with different charges, or the prosecution could drop the charges, or they could come to a plea. There are so many options. But as far as YNW Melly is concerned, if that jury decides that the prosecution has not proven this case beyond a reasonable doubt, he walks out probably that day from the courtroom, and he will be set free, and he does not have to worry about those charges. Now, of course, obviously, if the prosecution has other charges that they want to assert, they can. There's no double jeopardy claim there. But as far as his murder charges, he walks no matter what happens to Henry or anyone else that they determine might have been involved with this crime.
Okay, Michael, this one's for you. BX Three Ways from Thread asks, if Melly left his phone in the car, then how did he get it back? Wouldn't that have been in the detective's hands? That's a great question, because the Jeep was taken into custody immediately and put into a secure storage facility, according to all of the testimony that we've heard.
Yesterday with Mr. Davis, it really pointed out something I've talked about before, and that is, so what if somebody's phone is laying somewhere? It doesn't mean the person is nearby. So now we're hearing from this witness that the phone was left behind in the Jeep, and that's a great question. What happened to it after that? Where did it go? What was the trail of that phone to get back to Melly? I don't know that anybody's answered that question. It does cause me some concern when we have one of the defense witnesses, really just the witness, Mr. Davis, telling a bit of a different story than Trevion Glass, who was brought on by the prosecution, both talking about where Melly was. I'm not very satisfied with the story that, hey, we pulled over, he hopped in our car, the red car, not the Jeep, the Mitsubishi. I just don't know. That doesn't make sense to me. I didn't really hear enough to hear the why that would happen. All the guys were kind of, stoned and passing out in the Mitsubishi, and just decided maybe Melly'd like to crash here too. I don't understand that. It doesn't make a lot of sense to me, and it does fly in the face of Trevion Glass's testimony, which was a little more vague, but made it sound like there wasn't that kind of, park, swap passengers, and move forward. I think that is very confusing, and obviously confusion is very good if you're the defense.
Very different demeanors, too, between Trevion Glass and Adrian Davis. Adrian Davis looking straight ahead when he's answering these questions. Trevion Glass didn't want to be there. You could tell. He's nervous, didn't want to be there. He felt like he had to be there or else he was going to get arrested. Also, the whole story about him, the phone went to the crime scene, according to the testimony we've heard. I mean, it's on a map. They showed it. So we'll have to see what the jury thinks of all of that. Be Taken Pics from Instagram asks, is there likely to be a hung jury? Natalie, what do you think?
Ooh, you can't predict something like that. But I will say this. For the evidence that the prosecution had, which at the beginning I was very skeptical about, towards the end I thought got a lot stronger, the defense has put on a heck of a case. They have cross-examined witnesses excellently, called things into question, made me question some things. And because of that, they just need one. They just need one person to say, I can't make a decision on this beyond a reasonable doubt. I don't know which way to come out. And so that could result in a hung jury. With a case like this, you just need one. So it's a possibility. It's not impossible. Although I do think that the state's case is quite strong here. I think the defense did an excellent job.
We have this next question for you, Terry. More Q's than A's from YouTube asks, is the jury allowed to not believe a witness under oath?
Well, the jury is absolutely allowed not to believe a witness under oath. They are there to assess their credibility for each and every witness, and it's up to them to determine whether or not the witness is credible. And they're going to base that on what the witness said compared to what other people said. They're going to base that on his body language. They're going to just base it on whether or not he or she is evasive. So all of that are questions or fact, and all of that is something that the jury is supposed to decide. And Jeanette, before I let you move on, we did just hear from a very reliable source that there will not be a 1:30 session in court between the lawyers. My assumption is that is because the issue of that last final charge, felony murder, has been resolved. I don't yet know how it's been resolved, but it's been resolved. So there will not be an argument or a discussion between the attorneys at 1:30 today.
Very interesting. We will look into that. We'll go check the docket and see if anything's been filed regarding that. Ray from YouTube asks, this is for you, Michael. Did the prosecution ever prove premeditation? Wouldn't they need to convict Melly for first degree? Wouldn't they need that, I think is what they mean. And not to mention, they never, that I saw, proved a motive or produced a weapon.
Yeah, obviously we know, excuse me, the weapon is not an issue. Don't have that. Motive you don't need. So let's talk about premeditation. You do need that. You need malice of forethought to prove first-degree murder. But what people start to get confused about is they think that, hey, I needed to sit down this morning while I was having breakfast and start penciling out how I'm going to kill somebody. That's not the way it works. You could have that premeditation, boom, just like that, just before you pull the trigger. So that's not as hard to prove as people might think, because the nature of the acts generally suggest it. If it's not a struggle over a gun, if it's not a heat of passion, I just found my wife with another guy, if it's not those kinds of things, then it almost defaults to premeditation, because then how did you end up with a gun pointed at somebody, shooting them and killing them? Accident? You know, so that's really not as big a deal. In this case, obviously, it's the whodunit. You know, that gun, missing or otherwise, I don't think has been very strongly put in Melly's hands. I think it's been put in the hand of somebody in the back seat. The question is whether the jury thinks the prosecution has done enough to put the gun in Melly's hand while in that back seat.
Most certainly. All right, we are going to take a quick break. When we come back, we'll get to more of your questions. Keep them coming in on YouTube, Twitter, Facebook, Instagram, Threads, and TikTok. We'll get to as many of them as we can. I'm Anjanette Levy, and you are watching Law and Crime. Welcome back. I'm Anjanette Levy, and thanks for being with us here today on Law and Crime as we take your questions about the YNW Melly double murder trial. Closing arguments are going to be held in that case. Starting tomorrow morning, we'll have them covered for you. Melly, of course, on trial for the murders of his two friends, Christopher Thomas Jr. and Anthony Williams, back in October of 2018. His co-defendant, Cortlen Henry, will go on trial later this year in October. We're going to get to more of your questions right now. Let's get to this one. I thought this was a really good one for you, Natalie. Lavender from YouTube asks, do you think the death penalty was a reach with only circumstantial evidence? Remember, with Casey Anthony, the jury decided the state didn't prove its case, but we all thought she was guilty.
So yes, I actually do think it is. If the aggravation that they want to go on is that this is somehow gang related, I just don't see how that's the case. It wasn't proven to me. And I think that if Melly has a good chance at an appeal, if he is ultimately convicted, and let's remember he's still innocent until proven otherwise. But if he is ultimately convicted, his best chance at his appeal is how much the trial was polluted with this gang evidence, which I don't think ever showed that that was a motive. And they're going to try to use that as an enhancement for the death penalty. And I just think that that is excessive, that they're doing too much there, that there's no proof that this had anything to do with a gang relationship. And now when it comes to, the whole Casey Anthony case, that's apples to oranges. She wasn't convicted at all. So we'll just have to wait and see what the actual outcome of the verdict is before we determine what's going to happen with the death penalty. But I do think it was a reach.
Yeah, Casey Anthony taking us way back, way back to 2010. Taurus from YouTube, Terry asks, are jurors allowed to ask questions during closings?
Not during closings, to my understanding. For this court, this judge, he obviously will allow them to ask questions during their deliberation. And there's a system in place here where if they have a question, they have to, by the way, when they're deliberating, they have to be in the courtroom. They're taken back from the hotel to the courtroom. And there's a system, if they have a question, they buzz once. If they have a verdict, they buzz twice. So they can ask as many questions as possible. And we have seen them asking questions along the way. They've sent in notes. One juror said she was uncomfortable with Polo. If you remember, Danny Polo had the mask on and she was very comfortable. He's the one who talked about the gang affiliation that Natalie referred to, and it did go on for quite some time. So one juror sent out a note saying she wasn't comfortable, that she had some trauma in her life. The judge brought her in. The judge spoke to her, and we had subsequent questions as well. It wasn't during the trial itself. It was during breaks that she sent in those questions, and the questions were answered by the judge and by the attorneys once she was called in by herself, outside the presence, by the way, of the rest of that jury. So during the closings, I don't believe they will be allowed to ask any questions, but during the deliberations, if in fact they had a question in their mind about the closing, they can certainly ask it at that point in time. They can ask anything they want about the evidence. It can be brought back about something that was said, and then the judge will talk to the attorneys and say, look, here's the question. What do you think we should say? And the judge ultimately will come up with some wording to read back to the jury question.
And they don't always get the answer they want, the jurors. Like sometimes if they want testimony read back, Terry, sometimes the judge will say, no, you have to rely on your recollection. They won't do that. It just depends on how the judge sees fit and if the defense attorneys and prosecutors can agree on the answer. Threads, a question for you, Michael Bryant. King Easy Black asks, if Melly gets found not guilty, the experts already said both shots came from the back seat. So why wouldn't that be enough to get Bortlen off?
Yeah, I think it's a great question, and I think it really, if you think about it, King, it sort of ties the hands of the prosecution in round two against Cortlen Henry, because after you've had this, and this is, it'll be public transcript, it's admissible in a subsequent trial. Here you have an expert that goes into great detail about how these shots were fired from the back seat. Unless the prosecution comes up with some evidence that Cortlen Henry at some point was in the back seat, and I've heard nothing in this trial, not quite as relevant here, then you're right, King. How do you use that? You've got to come up with something different. That's why I think felony murder makes much more sense in the Cortlen Henry case, because obviously the predicate felonies would be the murders by what the prosecution says as Jamell Demons. But that's not the case here, and you guys, that ruling the judge is yet to reveal, to me makes no sense anyway. If you have two people shot and killed, it seems to me, unless you can say they died at exactly the same moment in time, then one of them certainly predeceased the other, and who cares which one it was? You should still be able to use that prior death as the predicate felony for felony murder. Just me. That's what I'm thinking.
Well, somebody had to be shot first.
Of course, somebody had to die first, and so if
unless
I don't see that they can cop out.
I don't know anybody that can shoot. Yeah.
Well, and nobody was there to say they died at the exact same time. Well, and if they didn't die at the exact same time, somebody predeceased the other. I think you have to allow it.
TikTok. Question from TikTok for you, Natalie Riker KS. You've kind of touched on this previously, but I'll ask again. How do you think the defense handled some of the evidence that could go against Melly?
I think that they handled a lot of the fact witnesses very well. So calling into question their memory of things. And I also think that they had a great strategy of evidence blocking, challenging the evidence before the prosecution was able to get it in. So there's a lot of evidence that we know about that the jury actually was never able to see because the defense hammered home how those things are either irrelevant or unduly prejudicial more than they are probative. And because of all these objections that the defense raised, they're going to have an excellent appellate record if it becomes necessary if Mr. Demons is convicted. And you can't get an appeal on things that you don't object about. So those objections were really, really on point in the defense's case. And they raised a lot of questions for me. The best evidence that they dealt with was the phone evidence, because that was the most important. I did it. They did establish that other people used YNW Melly's phone. Whether or not you think in that moment it was him or someone else talking, that's up to the jury. I personally think it came across like it was Melly sending that text, but they called into question distinctions in the way that he wrote and the fact that other people did business from his phone, pretended to be him, used his phone while he was in jail. So I think that they did a really good job calling those things into questions.
B_Reelin802 from Instagram, Terry asks, major question I have. Why hasn't anyone brought up the obvious facts about Melly's mental health? He has openly admitted to being schizophrenic. I'm not sure about that part. We know there's been some other talk about his mental health issues and having split personalities. This plays a major role with testimonies like this one. So why hasn't his mental health come up, Terry?
Well, it hasn't come up because probably the judge made a pre-ruling prior to the trial that it can't come up because there's no medical evidence to that effect. If, in fact, he did say those things on social media or he's admitted it to friends in a video, there's no evidence in this trial, and to my knowledge, evidence outside the trial, medical evidence that the judge can substantiate and say, okay, let's bring it into trial. If it's not substantiated, if it's not a report from a medical person, and if it's not introduced into evidence, the attorneys cannot refer to that. Neither side can refer to that. So based on what we know, and all we know is what the viewers are telling us or what we may see on social media, but none of that means that he's been medically diagnosed with any sort of mental illness. And if that is the case, the judge probably, and I don't know if there was a pretrial motion to this effect, but if the issue came up and the judge has not seen any medical evidence to that effect, he may have said, look, no one can make reference to that unless I see something otherwise. So that's probably why no one has seen that in this trial at this point.
Well, also, it may just not be relevant, and it's all, this is material you would talk about for mitigation, not necessarily in this portion of the trial. Also, I just want to throw in an answer to that as well. I interviewed Track last week, the manager for Melly, and I asked him about the split personalities, and he said that's an act. Melly Melvin, it's kind of like Beyonce and Sasha Fierce, it's like just one of these things. It's part of the act. So just wanted to let everybody know that. You can watch that episode of Sidebar on our YouTube channel. Stay with us. We'll be right back. We'll take more of your questions. I'm Anjanette Levy. You're watching Law and Crime. Welcome back. I'm Anjanette Levy. Thanks for being with us on this Wednesday afternoon as we wind down this hour of taking your questions in the YNW Melly double murder case. Let's get right to them. We've still got a lot of great questions left. Michael, TJ's New Life from YouTube asks, if Melly is found guilty, that will automatically make Bortlen guilty of accessory, won't it?
No, not necessarily. I mean, you're not an accessory just because you're in the car, assuming he was in the car. He has to do something in furtherance of the crimes that Melly, if convicted, is convicted of. So, yeah, being in the wrong place at the wrong time isn't a crime.
Right, exactly. I mean, it all depends on the facts and the, surrounding him being in that vehicle. And what they'll be able to establish at his trial, should he even go to trial. We just never know what could happen. Charles Thorpe from YouTube. Natalie, why aren't they facing the same charges? Bortlen, I think, is what he means, and Melly.
Because Melly is alleged to be the shooter, simply because they have video of Melly getting into the backseat of the car. They had the crime scene reconstructionists say that the victims were shot from the backseat of the car. And then they have the text message from Melly's phone saying, I did that, with the smiley face. So for that reason, they're pinning all their hopes and dreams on Melly being the shooter. And what they're saying is that Bortlen helped with the cover up. He's the one that gave the initial story to police that this was a drive-by shooting. They're saying that maybe, or suggesting he may have participated in doing something to stage the scene to look like it was a drive-by. And we're going to have to wait to see in Bortlen's case what evidence they have against him in particular, because they didn't really get into that in this trial. But that's why they have two different sets of charges.
Mm-hmm. Most definitely. All right, let's get to the next question. Mercy Mighty from YouTube, Terry, was there any reason why the prosecution did not invite the driver of the red car to testify, since everyone else in the red car was asleep? Invite is kind of only, that just made me laugh a little bit, because prosecutors don't typically invite people. They send you a document saying show up or else.
Well, that's a good question. I think they probably tried to get everyone in that car at the trial, everyone in that red Mitsubishi, but they could not. Now, we do know they got Travion Glass, and he did testify. His testimony was a little bit vague, and obviously they got Adrian Davis. But as far as, Dontavius Williams, and I think the other one's name is Jacoby Mills. I forgot his whole name. Thank you, Jacoby Mills. They haven't referred to him that often, which is why I think I keep forgetting that name. But they probably did try to get them in and subpoena them. They would, I think both sides would need to have as many of the witnesses who were there that night. But it's been very difficult to get these witnesses in. They have difficulty finding the addresses. And even once they find the addresses, they've been having difficulty getting the subpoenas served. And there have been, wrong addresses. So it's been a big issue for both sides to get these witnesses in. And I think it was a surprise that they, at the end of the day, did get Adrian Davis to come in. I think when Travion came, Travion Glass, people were a little bit surprised then. People were even more surprised. And when I say people, I mean the people in that courtroom, even the jury. When both of them walked in, there was sort of like, oh, okay, we have a civilian and we have someone who is a direct witness other than, this circumstantial evidence that we have. So both of them were important, and I do believe they tried to get all four, but they were not successful. And frankly, I think both sides were lucky and fortunate to have two.
Yeah, they did try to get all of them, and they talked about that. Jacoby Mills, Dontavius Withers, and even Mariah Hamilton, Melly's girlfriend. There's a warrant, basically a warrant out for her arrest for not, responding to a subpoena. So they tried to get all of these people to come in. They didn't want to. So that's a big part of why people didn't hear from them. Let's go to Natalia Lancaster. From YouTube, Michael. Based off of previous precedents where judgment of acquittal was requested, do you believe that the defense has standing to get this approved?
You mean, will they be successful in that request? Denied. Remember, it's an important maneuver. It needs to be done for purposes of appeal. But you're actually asking the judge to say, and remember, the judge decides things as a matter of law, right? The jury handles the facts. The judge has to say, as a matter of law, no reasonable person could have any difference of opinion on these facts. Are you kidding me? In this case, there are cases where you might occasionally think, I think they're right. But it ain't this case. No, the motion was denied properly, and I don't think even on appeal it has a shot.
And, we have seen cases where those are granted, but it's pretty rare that you see that granted. Ashley M. from YouTube, Natalie asks, when Travion Glass confronted Melly via Facebook asking what really happened, Melly didn't say they were in the same car and went home together. How does this affect Adrian Davis's testimony?
It's another thing that calls into question Mr. Davis's testimony. Internally, Mr. Davis had some inconsistencies during his testimony between what he said previously to the prosecutor and then what he said on the stand. And then externally, what other people have said contradicts his testimony and what he said on the stand. So it's just another thing that if the prosecution is smart, they'll make a chart of everything that was inconsistent that was in favor of Mr. Demons, and they'll show those inconsistencies to the jury in some type of visual example so that they can keep all of that together when they go back to the deliberation room, because it's easy to miss those things or forget about them with a 5-week trial.
Most certainly. And both sides wanted to have very long closing arguments, and we found out that may not happen. They will be limited on their time, but both sides have a lot to say, and we expect them to say a lot tomorrow, and we'll have it covered for you. Natalie, Terry, Michael, everybody, thanks for being with us. Thank you all for being with us as well. Michael Bryant is going to take it over when we come back from this break. I will be signing off. I'm Anjanette Levy. You are watching Law and Crime.
good afternoon and welcome to the Law and Crime Network. I'm Michael Bryant with you for the next couple of hours here. Hope you got a chance to enjoy the Q&A session, Anjanette Levy, and going through all the things with the Melly case, or as I like to call it, the third degree with Anjanette Levy. Anyway, good opportunity to hear what's on your mind. So we've been doing that every day at lunchtime, and I believe that will continue as this case wraps up. So we're going to talk about, among other things, the Broward County, Florida case, both sides having rested now in the YNW Melly case. It's a double murder trial. So no court today. They're getting ready for closing arguments. Those are going to take place tomorrow. I heard they were asking for 4 hours each. Are you kidding me? If you can't tell this story in 2 hours or less, the jury's going to be zoning out on you. But anyway, that's going to happen tomorrow. Today we have a chance to review the case. And of course, this is the story of the 24-year-old rapper, Jamell Demons. He is looking at possible death penalty for the 2018 shooting deaths of his two friends, Anthony Williams, Christopher Thomas Jr. The victims were on their way back from a recording session. They're in the car, allegedly with Mr. Demons, depends on which witness you believe, and the co-defendant, Cortlen Henry. His trial coming up in October. This all took place in October, but in 2018. So they say they're innocent. This was just a drive-by. They just caught up in a drive-by shooting. Prosecution, though, they say, look, man, the evidence suggests the shots were from inside the vehicle. So, state took 15 days. It seemed like so much longer because it was kind of a stop and starter of a trial. But they were in court 15 days. They put on their evidence. The defendant using just really 1 day and one witness, but they're really presenting their case in the form of cross-examination through that entire 15 days that the prosecution's doing their thing. So I think they did a pretty good job. This is really quite the case in terms of where it's going to go and what this jury is going to do with it. Let's start today by taking a closer look at the state's case. This is a report from our very own Terry Austin. Let's go.
Rapper YNW Melly is on trial for the shooting deaths of two of his best friends, Anthony Williams and Christopher Thomas Jr. The Murder on My Mind artist born Jamell Demons is facing the possibility of the death penalty if a Broward County jury finds him guilty. The state started its case with a string of experts and law enforcement witnesses. But things started to heat up when prosecutors called Felicia Holmes, the mother of the defendant's ex-girlfriend. Prosecutor Christine Bradley tried to highlight changes in Holmes' story since her first statement to police.
December 2022, you said that this is a correct statement.
Objection. Sustained.
So, Ms. Holmes, is the December 2018 statement that you gave correct and honest?
Objection.
Is this December 2018 statement correct and honest?
I don't remember the December 2018 statement.
Then we had undercover detective Danny Polo, who spent most of his testimony in a ski mask to protect his identity against credible threats to his life. Polo linked the defendant to the G-Shine gang, an affiliate of the Bloods.
That's a really commonly used blood hand sign, spelled out blood, B-L-O-O-D, using both hands. So Mr. Demons using both hands to throw up the big B's for blood. We're supposed to be bloodas, not brothers, but bloodas. Just let me know what's going on, that's all. So again, using blood terminology in his language, that is just more evidence of the association or membership to the Blood Nation.
It wasn't until medical examiner Dr. Rebecca McDougall took the stand that we learned victim Anthony Williams was already dead before he was struck by two more bullets.
Based on your autopsy, did you come to an opinion as to the cause and manner of death for Anthony Williams?
I did.
And what was that?
The cause of death is multiple gunshot wounds, and the manner of death is homicide.
Was the victim, Anthony Williams, dead when the B and D was inflicted to the body?
So when gunshot wound B was inflicted, yes, he was dead.
Melly and his co-defendant, Cortlen Henry, claimed their innocence, saying they were victims of a drive-by shooting. However, many witnesses, including reconstruction expert Sergeant Christopher Williams, testified that the shots came from inside the vehicle.
How many rounds were fired inside of the car?
3.
And can you exclude the shots to the head for Mr. Williams and Mr. Thomas as coming from outside of the car?
Yes.
Another key witness for the state, Trevion Glass, testified that Melly changed his clothes after he left the recording studio the day of the murders.
Was that the first time you saw Melly after you guys left the studio?
Yeah.
Was Melly wearing the same clothes or different clothes than when you saw him at the studio?
It was a new bit. Nah, he wasn't.
Nah, he wasn't. You guys
Wasn't wearing the same clothes.
Okay. Do you recall what he was wearing?
Just had on some shorts.
And finally, the state wrapped up its case by calling lead detective Mark Moretti to the stand. It was during his testimony that prosecutors presented the bombshell evidence they mentioned in opening statements, an Instagram message that they believe is a confession.
What does the YNW Melly account state?
I did that with a smiley emoji.
In terms of what was that in response to from the PZ Gambino account?
Objection. Overruled.
The PZ Gambino account asked him if he was okay, and his response was, I did that, and placed a smiley face emoji. After that, SHHHH.
Ultimately, it will be up to a jury to decide the credibility of the state's case. I'm Terry Austin reporting for Law&Crime.
And Terry, of course, still down there covering this case for us, and she'll be there for the closing arguments, which begin tomorrow. So joining me is Mitra Ahuri, and she's with me from Los Angeles, also rap and hip-hop legal expert Afi Patterson, who has been with us throughout this trial, bringing some very interesting insights. So thanks for joining me, folks. I appreciate it. Let me start with you, Mitra. You know, now we get to sit back and say, okay, the prosecution's done. Have they done their job? Is the jury going to go their way? So let me just ask you your overall thoughts on the presentation by the prosecution.
You know, I think that what they presented makes it very hard for you to think that there was an alternate theory. And, you know, does that mean that there's reasonable doubt? You know, maybe, maybe not. I can't really answer that question quite yet. But I'm going to say, you know, you see Melly leave the studio. You see him get into the back seat where the expert said the fatal shots came from, right? And then you have this cell phone that, you know, maybe was used by others, but I think that, you know, was established that was primarily used by Melly. And then, you know, so then the other stuff is sort of, I think, questionable, you know, changing clothes after a long day of work. That's the first thing I do when I get home. So there's a few other things that sort of have me questioning, but I think that there's enough there for me to say, I'm having trouble with an alternate theory here.
So, I mean, this is really, I think, going to be a very close call for the jury. I don't think it is easy, and I don't see it as, boy, we got to convince one or two people. I think hung jury is certainly a possibility. Afi, one of the things that I think leads me to that thought process is the text, first of all. I did that. I'm not sure I believe he did that, meaning the text. It just seems odd unless you buy the whole gang affiliation issue and suggest that, well, he did that because that was to, you know, in part to impress folks he was trying to impress with the murders in the first place. And then you have the last defense witness, Mr. Davis, who came across, I think, credibly, but has such a different story to tell. I don't know. It may just be enough to confuse the jury. And to me, confusion leads to, at the very least, hung jury. What do you think?
Okay, so that's a great point. So Melly's alibi witness, Mr. Davis, took the stand, I believe it was yesterday, and I actually found him very credible. But the problem is I also found Trevion Glass very credible. So I'm trying to figure out how I reconcile the two, because I believe that the alibi witness gave him a very solid alibi. But what I think neither side really dove into was, why did Melly switch cars? I think they offered a reason. They tried to inch a reason in there, and that was because only Melly and Bortlen had keys to this apartment that 8 gentlemen were apparently living at. So I think that's a reason that they sort of offered. Maybe that's going to be reason enough for the jury, who knows? But also, I think the prosecution, their explanation about the Instagram confession, I think that's going to be, you know, a hard buy. It doesn't really give us context, and I have never really bought the gang reasoning for the murder. I think that Melly may be gang affiliated, but I don't think that he had to, pull off some type of murder as some sort of initiation for the gang. So I think that's going to be hard for the prosecution. But what I would do is focus on the phone, because we pretty much believe now that 9807 number, I think that's the last 4 digits, that's Melly's phone. So I would follow the phone. What was it? FTP. That's what I would hammer home to my jury.
Follow the phone. Okay, we're not following the money here. We're following the phone.
Follow the
All
phone.
right. It's confusing, and again, I always think confusion is not a bad thing for the defense team. I do know now that I will. The whole gang thing, it'll never work. I cannot do that. I cannot make that. I don't know how that is done. So I'm out. Okay. Let's take a break here, guys. We'll come back, talk more about the Jamell Demons case. Again, the closing arguments are tomorrow morning. Be right back.
tape, done reviews.
Okay. You know who got into the Jeep?
Cortlen, Jamell, Sack, and Juvy.
Where were you going?
Home.
Did anyone fall asleep in your car?
Yeah, we about all did except for the driver.
Did there come a time that you were woken up before you got to the house?
Yes.
What happened?
We pulled over, and that's when Melly got in the car with us.
Do you know where you pulled over?
And I don't really remember.
Were you woken up?
Yeah, but
Why?
it was like, because I was getting pushed over a little bit.
Were you woken up?
Yeah, but
Why?
it was like, because I was getting pushed over a little bit.
And are you 100% sure that this young man got into the red Mitsubishi?
Yes.
What happened to the Jeep?
I think they just kept going.
Did he have to unlock the door?
Yes.
Do you know who has the keys to Melly's house on October 26th in the early morning hours?
Jamell and Bortlen. They're the only one who had keys to the house.
Did you have a key to the house?
No.
Did Williams have a key to the house?
No.
Did Christopher Thomas have a key to the house?
No.
Did Trevon Glass have a key to the house?
No.
Did Jacoby Mills have a key to the house?
No.
And how about Dontavius Williams? Did he have a key?
No.
Okay, so the only two people you know who had a key to the house was this young man.
Yes.
And Cortlen Henry.
Yes.
Did you see this young man unlock the door of the house?
Yes.
Who was the last person to get out of the red Mitsubishi to go inside the house?
Trayvon, he was in the car still asleep.
He was in the car asleep when you got to his house?
Yeah.
So there he is, the star defense witness, Adrian Davis. Now, a lot of these cases, and we thought it was going to happen in this case, we have the battle of the experts, because there was the reconstructionist, the shooting reconstructionist for the prosecution that ended a couple of weeks ago and was toward the end of their case. We thought it was strong. We thought for sure the defense would have to come up with their own expert to refute that the shots came from inside the vehicle. But they never did that. Instead, they have this guy as their only witness. So instead of the experts battling, we have the battle of the stoners dudes. And I mean that I'm not pejorative about it. Have a little ganja whenever you want. It's not illegal. May affect your testimony, may affect your recollection. Afi Patterson's here, Mitra Ahurian. Afi and I have both suggested, Mitra, that this guy came off credibly. So let me get your take on it. What do you think of Mr. Davis?
Well, you know, you kind of raised the point that I'm thinking as I'm watching his testimony. Let's say we believe everything he's saying, right? So an alternate theory about Melly not being there and why he's not there, and he has the key and he jumped out of the car and all that. But we're not seeing an expert, right? So who else did it? Did someone else hop in the car? You know, was it Cortlen? Because he's the only other person who's alive that we know was in that vehicle. So even if I believe that, that his best friend is credible, I'm wondering, okay, we had an expert who testified that these shots came from inside the car. Who did it? And I just don't know if that's enough. His testimony is enough reasonable doubt for me.
Yeah, and it does raise a question for me when we start thinking about the Cortlen Henry trial to come, Afi. Maybe there was some maneuvering and Melly did get out of the car and Mr. Henry got in the back seat and that's where the shots were fired. It was maybe all part of that exchange. That's not impossible.
Well, okay. So I need somebody to make it make sense for me. Tell me why he got out of the car, why Melly didn't originally take the red vehicle to go straight home. I don't know. There hasn't been an explanation, but I think it was brilliant that the defense said, we're going to rest on our alibi witness and that's it. we don't need a reconstruction expert, because I think if the defense gets a reconstruction expert up there, originally I did think they needed one, but if the defense gets a reconstruction expert up there to refute the prosecution's version of events, that is going to put Melly there in the juror's mind. It's going to basically show me that the defense is trying to say, hey, there could have been a drive-by shooting. Melly could have been in the seat and scooched back, and someone could have shot these gentlemen. It puts him there in the minds of the jurors, and I think that's a bad idea. So I think that not having a reconstruction expert, it's not their business. They don't need to have one up there. They needed an alibi witness, and that's what they got. I think the problem is the jury always wants to hear the defendant's version, the fact that he's not testifying. I don't think he should have, but that's one problem. And you just said you have a battle of the best friends. So who are we going to believe? Is this alibi testimony kind of like a wash because we're going to put it up against Travion Glass's testimony and they don't comport, so it's a wash, so it really doesn't matter? Like, those are the questions. But again, I don't think they needed a reconstruction expert.
Yeah, it's a bold decision, but I agree with you for the reasons you state. But it is kind of an all or nothing proposition here. So with Mr. Davis being so important, we've seen the direct. Let's take a look at the cross-examination of this witness.
Mr. Davis, you said you're 100% sure that Mr. Demons found out at the same time you did.
Yes.
No questions about that. You're sure he was at that house?
Yes.
And you were upstairs?
Yes, ma'am.
He was downstairs?
Yes.
But you're sure he was there? You could see him? Is that a yes?
Yes.
And you are 100% sure his phone was missing?
Yes.
Where in this statement on May 5th did you ever say that?
Objection.
Suggestion.
It was never asked.
Thank you. Counsel, so I guess the objection is improper impeachment, so rephrase your question.
So, you met with me on May 5th, 2022, you remember that?
Yes.
And you remember sitting down, you were present? That's a yes?
Yes.
Your two attorneys were present that you brought? That's a yes?
Yes.
And I asked you questions for quite a number of hours. Do you remember that?
Yes.
Okay. And do you remember being asked if you had met with anyone else with regards to this case?
Yes.
Okay. And do you remember being asked if you had met prior to speaking with me with the attorney sitting over to my left?
Yes.
Okay.
I didn't know who they were, and my lawyers told you that.
Okay.
I didn't know their names.
But you remember meeting with them?
Yeah.
Okay. And do you remember asking and being asked a question about what you talked about with them?
Yes.
Did you remember what you told them?
No.
Do you remember what you told them now?
Yes.
So are you telling this jury that when you were speaking with me, you forgot?
As in, what I'm telling them now, as of right now, yes.
Okay, so we always get to learn some procedural stuff here as we're watching these trials unfold on Law and Crime. Let me just give you a tip here. Objection, he wasn't asked that. That's not a formal objection. That doesn't really mean anything. And when the judge then formalizes the objection for you, you can kind of feel like you've been spanked because, lack of foundation. Anyway, let's find out how my panel thought he did on cross-examination. So, Mitra, what do you think? There was a big discussion during the course of this trial about the inadequate preparation, the inadequate investigation. Prosecution here suggests, we had quite the conversation, and now things are coming out a little differently here on the stand. How do you think he did?
I think that's important to point out, and I think he did okay. I think he did as well as he could have done, given the facts, given that they did meet. But it doesn't mean that was enough. And I think that he answered the questions confidently and truthfully, and that's really all you can expect.
So, Offie, maybe he's just a sociopath. Maybe he just, he can lie like the best of them, and it just comes across as the truth. I mean, it happens.
Again, he came across as calm and credible and forthcoming to me. But what I thought was so interesting during that cross-examination is the fact that the Detective Moretti never interviewed him. And this is the same Detective Moretti who said that he could not get, like a judge would not sign off on a search warrant of Melly's house at any point, even in May of 2023 when he was still investigating this case. So it just goes to the credibility of the state's case and the credibility of the investigation.
Yeah, there were many criticisms of that investigation. When the prosecution is the only one that has the interaction with this witness, 5 years later, 4.5 years later, you got to wonder. That's a long time to kind of get your ducks in a row. And this witness, I think, took advantage of that. And the prosecution looked a little flat-footed. So we'll see what the jury does with that. Again, the closing arguments will be tomorrow in the Jamell Demons case. We'll come back right after this. There we are. Welcome back to Law and Crime. We continue our coverage of the YNW Melly double murder trial. We are doing a little dissection and speculation and pontification because court starts today, closing arguments in the morning. So let's take a closer look at one very key individual in the state's case, the lead detective, Mark Moretti. At the very end of his testimony, now early on, the state represented there was going to be this text message. They talked about it in opening statements. They promised it. They billboarded it. They teased it. Let's take a look.
On October 26th of 2018 at 20:02:18 UTC, what does the YNW Melly account state?
I did that with a smiley emoji.
In terms of what was that in response to from the PZ Gambino account?
Objection. Overruled. The PZ Gambino account asked him if he was okay, and his response was, I did that, and placed a smiley face emoji.
And the next message from 10/26/2018 at 16:02 from Eastern Standard Time, the YNW Melly account says what?
After that, SHHHH.
Could you please stand and point on the right side of the screen exactly which part you're saying where the YNW Melly account says, I did that?
I did that. This is the thread ID. This is the text. This is the author. And this is the recipient. They come down here, same thing. The ID is for the actual message, which is just specific to that one message. Then the thread ID is the actual continuation of continued message. They come down here, it just says text, the SHHHH.
I did that, not I did that. I did that. That was the smoking gun, as it were, the very last thing really presented in the detective's case against Jamell Demons. Afi Patterson is here and Mitra Ahurian. So, Mitra, the jury has to either believe that this was really a text written by Jamell Demons, and he just felt like kind of a pseudo-confession was in order, or somebody else did it on his phone, which of course, with my distrust of who's typing texts and who's phoning whom from a given phone at a given time, I think is equally believable. What do you think?
It's not out of the question for me that he sent that text. I think that, the argument that he normally says DAT, he normally spells DAT, dat, instead of that. I think that's fair, but I would, if I was the, prosecution and I'm responding to that argument, I would want to see at least one or two other instances where we have THAT there, and whether that, that would be admissible for that purpose, I don't know. But, that's something that would help me as somebody who's looking at that, and that being some of the presentation of why that would not be him. And then we also, do have the question of who was actually, who had this phone. There's multiple people who had it. But I can also find reasons why he would admit to something like that, and why he would, why he would sort of boast about something like that. And so, yeah, for me, it's hard, but, to call it the smoking gun that I'm waiting for, that's the 100%, this was the admission, I don't think that I can take it there.
So, Afi, what is your thought on dat or that? We know there was testimony and evidence that more often than not in text, Melly does say dat, D-A-T. Not conclusive. Again, it just seems to me to be inconclusive and therefore leading to something that favors the defense.
I don't know. If you want to take it as a confession, if you're inclined to believe the prosecution and that the defendant is there for a good reason, you'll easily, if you're a juror, you'll take that as a confession. I think what's more important for me is the context of I did that. I did what? There's no mention of the murders immediately before or after. It's just how are you doing? So I think the stronger play instead of the DAT versus that is the context. And if this is a confession, why is Melly confessing to this person? What's the significance of that? How is that going to help him or just advance his cause in life? It doesn't make sense to me. Nobody really brought that out. But the that was interesting because immediately after the break, the prosecution came back and easily pointed out multiple times where he spelled the word THAT. So.
Yeah, and again, I think inconclusive is the best thing you can say about it, because it's just so stupid to confess to doing something like that, that it makes it, to me, unrealistic, or somebody else taking his phone and boop, 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 sending out that text. It's too easy. Okay, so let's hear from the defense now and see how they handle this. Here's their line of questioning for this message.
Will you tell the jury how he spells that?
D-A-T.
D-A-T. Page 2. Will you tell the jury how he spells that?
D-A-T.
D-A-T. Not T-H-A-T. D-A-T, correct?
Right.
Page 3, coming out of 9807. How does he spell that?
D-A-T.
So when Melly spells the word that, you want me to go through all 19 pages? Or will you take my word that every time, coming out of 9807, that's attributed to this young man that's writing the message, he does not spell it T-H-A-T, but D-A-T. Would you like to look through them?
No, sir. You're asking me to explain that the one moment he decided to use proper grammar.
One moment, these phone messages sitting there.
One at a time. All right. What's the objection? Overruled.
These phone messages that the state introduced sitting on this pages that we painfully went through, he spells it D-A-T, not T-H-A-T, except for this one occasion. Right?
Correct.
What a strange thing. I'm sorry, Judge. I apologize.
Counsel, why so angry? I know it's cross-examination, but come on, I mean, putting papers in the witness's face and everything. So I think, Afi and Mitra, we've beaten to death the dat and that. So let me just ask you about a little courtroom procedure and the demeanor of this particular attorney. We know that Cross, Afi, is a little more in your face, but this guy really gets in your face. Do you think that can have some counterproductive characteristics to it in front of a jury?
It can, especially because the defense has been pretty calm, cool, and collected throughout. They've been, I guess, very stern in some places, as they should be, but since this gentleman has been up, he's been a little aggressive at times, argumentative at times, and seemingly agitated at times. And your jurors are going to look at that and say, why so frustrated? As you said, why so angry? And it may not sit well with them. A lot of deliberations, I guess you can, an attorney's demeanor is going to go into how you deliberate and how you decide the case. And you kind of want to leave your jurors with a good feeling, a good confident feeling, not a feeling that you're agitated, which that energy is going to transfer to me and make me agitated. So.
Yep, never underestimate the power of likability, and that's everybody in the courtroom there. Yeah. Okay, let's take a break here. Stay right where you are there, guys. Good stuff. We'll take a break. We'll come back more on the Melly case, closing arguments tomorrow. And thanks for rejoining us here at the Law&Crime Network as we dig into the Broward County case. Dark today in the case against Jamell Demons, getting ready for closing arguments tomorrow. I think producer Christina, at 10 o'clock tomorrow, I believe they're going to get back at it. Okay. So when they do resume, of course, we will be there. For now, though, we're taking a look back at the state's case. That brings me to Trevion Glass. You've heard about Mr. Davis, who was the defense witness. Both he and Trevion were among the dudes getting out of the studio that night, October 2018, and getting into the two different vehicles. So they left at the same time as the defendant and the victim, and this guy was interesting. Some found him to be combative, but kind of in a chill way. So it was clear he didn't want to be on the stand, didn't want to be answering questions. But if you haven't seen it, watch this testimony. We'll talk about it afterwards.
Was Melly at the house when you got there, from what you can recall?
No.
Did you see Melly at any time in the house?
No.
Right? So you go upstairs in Juvy's room, and what do you do?
Crash.
All right? Crash meaning?
Go to sleep.
Okay. At some point, do you wake up?
Yeah.
And why? Or how?
Phone calls.
Okay. Safe to say that your phone was getting a lot of phone calls, blowing up.
Yeah.
All right. And at some point, you answer the phone, correct?
Yeah.
Okay. What do you do in response to the phone calls?
I answered the one that kept ringing, and yeah.
All right. And so what do you do in response to getting that phone call?
I ended up at the hospital.
All right. Do you recall which hospital that was?
No, I don't.
Do you recall what city you were in at this point?
I was in Broward.
All right. What city? Not the county.
Miramar.
Okay. Do you know if you went to Miramar Hospital?
I don't know what hospital it was.
Okay. So you get to the hospital. What do you find out when you get to the hospital?
That Anthony and Christopher was deceased.
Well, he's back there somewhere, kind of behind the computer monitor, probably hiding as best he can, because he really didn't want to be there. But the quote of the trial from Mr. Glass, "I smoke when I smoke." And no truer words were ever spoken. Afi Patterson is here. Mitra Ahurian. Let me ask you this, Afi, because I think there is a cultural issue in this case that this jury subliminally or otherwise is going to be dealing with. I mean, this business, the music, the hip-hop nation, as it were, it's a different lifestyle. Whether it's smoking, drinking, late-night work, it's just different. What kind of impact, if any, do you think it has on this trial and a jury?
A lot. Two things. I was just thinking now that we're getting into closing arguments, it's really time that we start looking at the demographics and the experiences of your jurors. Trials are won or lost during voir dire jury selection. So that's going to be a really important thing. And if you recall, a couple of weeks ago, Cortlen Henry was requesting some relief from his bond conditions. And something that the prosecutor was saying is, why does he need to be at the studio at 11 o'clock at night? She just doesn't understand. And the argument was made that this is when the creative juices flow. This is the lifestyle. You go and you get 12 hours from 12 a.m. or 11 p.m. to 11 a.m. That's consistent within the industry. And I think there's, the defense is going to have to maybe explain that. That's commonplace.
Yeah, I think it is an issue, too. Mitra, I haven't forgotten about you. Let's watch some of the cross-examination of this witness, and then I want to get your thoughts on the other side.
Have you ever seen Melly with a gun?
Objection, Your Honor.
I sustain the objection.
Have you ever seen him track with a gun?
Possibly. Yes. Maybe so.
Okay. You don't know of any friction between Melly and Anthony Davis at any time, Anthony Williams at any time?
I know of.
And you don't know of any friction between Melly and Christopher Thomas at any time?
I know of.
And you don't know of any friction that occurred at the studio that night that would cause anybody to get murdered?
Objection, Your Honor. Call for speculation.
Sustain.
You didn't see any friction at the studio that night of any magnitude?
I did.
You did?
I didn't.
Okay, you didn't. Anyways, with respect to your daily marijuana regimen, did you smoke before you came here today?
I did not.
Okay. I have another question. Thank you.
I should have.
That's his one regret. He didn't smoke before he testified. Pretty low-key dude here, Mitra. And you know, he's there to, in part, say, look, these guys, they're friends. There was nothing between them that would lead Jamell Demons to kill his two friends.
Yeah, I mean, sure, he's there for that. But we also, you know, when you have a witness on the stand, you want them to contribute something concrete. And, you know, the defense at this stage, I think what they're trying to do is, yes, you know, maybe not, create some confusion or doubt. But at the same time, we're not getting clear answers from him. And I think that's probably going to be sort of frustrating to the jury. That, you know, did you see an argument? Did you know, or did you? I mean, he said no to that, but there were some, you know, answers before that made me wonder if there was some sort of tension. And we're just not getting the yes, no. I think one of the answers to one of the questions was, it's possible, yes, maybe.
Yeah.
So what exactly is the answer
there? I know. And Afi, you know, it makes the prosecution or the law enforcement look bad when they say, well, we tried to get these people that were in the car. I mean, what is it? Manpower issue? I don't think they were hard to find. If they just put up some sort of resistance, it sounds like the state just kind of went, nah, all right.
Definitely for on Detective Moretti's side, I think that argument can be made. But it also appears as if, number one, a lot of people that did testify, lay people that testified, were there under threat of prosecution. As we recall, Melly's girlfriend's mother basically said she's under some sort of house arrest, has an ankle monitor, and her daughter was threatened. This gentleman, Travion Glass, said that he was also threatened with prosecution, and that's why he was there. But also, it seems like there's a wall of silence that these possible witnesses have put up. So it's, you know, it's interesting. So something about Travion Glass's testimony. He was kind of combative on both sides. He wasn't really forthcoming with the prosecution or the defense. So I don't know what kind of credibility he has.
Yeah, it just seemed it was odd that he was the guy. That was the guy the prosecution used, because I don't know what kind of mileage they got out of him. He was entertaining, I thought, and of course, for me, that's important, but I'm not so sure how important that is for the prosecution. Mitra, so let's have a quick lightning round here. How much time we got left, Christina? Okay, yeah, plenty of time. This will be a quasi-lightning round then. Tell me what your thoughts might be as the jury gets this case. They're going to get it tomorrow. I'm not sure the closing arguments are going to change where they may be at this point. Who knows? Give me your thoughts on how long this thing goes, the impact of sequestration.
I think that it's going to take a while. I think it's going to be very hard one way or another to really, you know, decide whether he did it or didn't. There isn't really, to me, enough reasonable doubt, but at the same time, you know, do I 100% think he did it? No. And I think that's kind of a tricky place to be. And as a juror who sort of sat through this thing and is finally coming to the point where they're going to be making a decision. And let's not forget the death penalty is on the table. You only need 8 people to support the death penalty. So, you know, sort of having that in the back of your mind as a juror, assuming they do. And I think that it's going to take them some time to really come to a consensus. And like you mentioned, a hung jury is possible.
Yeah, let me ask you, Afi, in 20 seconds is what we got left here. What sequestration? Is that going to press this thing to a head by tomorrow?
Well, it depends on whether it's a full sequestration. I don't know if they're permitted to go home or if they're staying in some sort of hotel or something like that. But what I think is, you know, you want your jurors to be your advocates. You don't want to overwhelm them with anything. I think the prosecution needs to FTP, follow the phone.
Okay, follow the phone. Make a note of that. Thank you. Going to thank and excuse Afi and Mitra. Always good to have you guys. We'll see you next time here at Law&Crime. Stay where you are. We're coming right back after this. Hey, welcome back to Law and Crime. I'm Michael Bryant. Yet another hour of live analysis here. We are dark in southern Florida there. The Jamell Demons case continues in its darkness as they prepare for closing arguments, which will begin tomorrow morning at 10 o'clock. This, of course, in Broward County, Florida. They wrapped up yesterday. Everybody rested. And the only thing now is for the jury to take this case and decide what they're going to do with it. There is a death penalty, potentially a penalty phase if the guilt phase goes against the defendant in this case. So while we wait for those closing arguments, gives us a chance to go back to opening statements. Remember, this is the roadmap for the jury. Here's what we're going to prove. And if they were taking notes or thinking about it, now's the time where they start to think back when they're deliberating. It didn't come through with some of the things they promised. Did they deliver? Let's start with the prosecution, Christine Bradley's. Here we go.
So in summary, the last thing I want to tell you that the evidence will show is that in the Instagram, because the defendant had a moderate social media following at the time of these events, people are reaching out to him. Some fans, some friends, some associates. You'll see on October 26th, after about 8 a.m. in the morning, Eastern time, multiple messages are coming in. Messages are coming in from individuals checking to see if he's okay, if he's been injured in this drive-by. If it's true that Anthony Williams, who's also sometimes referred to as Sack, and Chris Thomas, who is referred to as Juvy, are really dead. One individual, and specifically, sends out, and I want to quote the message exactly that you will hear, and says, right after this, "Yo, homie, you good? Let me know something." And so, ladies and gentlemen, this is where context matters. What does that mean? If you work at Google and you say, "My whole floor is coding," that's a good thing. If you work at Broward General Hospital and you say, "My whole floor is coding," that is a bad thing. The context around the messages matters. So in the context of this message, this individual is reaching out, asking if Mr. Demons is good, after he's been tagged in multiple social media posts about this drive-through, this shooting. And Mr. Demons responds very succinctly, "I did that." Shh. Ladies and gentlemen, at the conclusion of the evidence, the state is confident that you will find the defendant guilty as charged of the first-degree murder of Christopher Thomas and Anthony Williams. Thank you.
All right, well, we know they came through with the text. The real question is, was it just so ridiculous that somebody would admit to having killed two people, or did somebody else write it in jest? Who knows? So I have a brand new legal panel here with me to discuss this case because the other folks got fed up with me and would not stick around. I have retired Special Agent Jennifer Coffindaffer here, and a criminal defense attorney, he says. Bob Mata is here, the host of Defense Diaries, the podcast. Thanks to both of you for being here. Appreciate it. So let me get your take, guys, on David Howard's opening statement. We're going to get to that in just a couple of seconds. So before I get ahead of myself, let me start with you, Jennifer, and ask you about the prosecution. We know this was a little nugget in their case. We know it was, in their minds, perhaps the final nail in the coffin, or should I say in the coffin daffer? What do you think? Was it really that powerful, or was it just, okay, let's see where this goes?
Well, first of all, I liked how this prosecutor presents. Very succinct. She made an analogy, which I thought was good, to show the importance of context, which in this case is important. You're talking about two people that have just been murdered, people that he's close to and knows. So this is an important moment, and to have a response that he had, which I believe was an admission, they're in black and white. And the shh, I think, is particularly telling. For me, I think it's a very good nugget, as you put it, for the prosecution.
Okay, so Bob, Defense Diaries, Bob, I think there's an argument to be made that it is so outrageous and so, on point that it could never be the guy that actually pulled the trigger. What do you think?
I don't know. Hi, Michael. Hi, Jennifer. I'm not sure, man. I've got to be honest with you. I'm kind of with Jennifer on this. I mean, he's a kid, and we looked through hundreds and thousands of his texts, and we just kind of see how he operates and how he operates with his mother and how he operates with his friends via text message, and just the timing of it in this day and age when you've got to know that they're going to get everything forensically that you text. I don't know. When you put the text messages in conjunction and look at the totality of the circumstances, they're pretty damning. I think ultimately if the jury comes back with a guilty on this, you can hang it right on those text messages.
Yeah, I think back to the Alec Murdaugh case, where it's the same kind of deal where you have a father, husband killing wife and son, and you just can't wrap your head around why anybody would do that. Here you have a friend killing two good friends. There's no dispute that they were friends and music associates. Now you have, on top of that, would you do it and then text something that is so incriminating? Again, something the jury's going to have to deal with. Okay, so now equal time to the defense. David Howard did the opening statement for the defense. We will scrutinize this as to the case they put on. Let's watch.
That's the first indication that they're just guessing and don't know what they're talking. And that, ladies and gentlemen, by itself is reasonable doubt. Why he would commit such a heinous crime against his own two best friends for no reason. What happened here is that the lead detective, Detective Murray, saw a video of Mr. Demons getting into a car 40 plus minutes before bodies were found in that car. And then he discovered that Mr. Demons was a rising star. And from that point on, he decided he's the only person that could have committed this crime. Because if you're involved in prosecuting a star, you become a star. This was his big break. And he had tunnel vision, and he zeroed in on this person, this young man, as the only possible perpetrator of that crime, to the exclusion of all other leads and evidence. There's a difference between cases that are investigated and cases that are fabricated. When a case is investigated, the state uses all its resources, its investigators, its experts, and all its energy to identify leads and run them to ground.
I do like the investigated versus fabricated. I like that pseudo-alliteration there. I think it makes the defense point here, and they, of course, went from that point, that was opening statement, to deride the investigation that was done in this case. Bob Motta, what do you think about that element in this case? It was a constant theme that the prosecution / law enforcement, they just dropped the ball. They didn't do half of what they needed to do, and that's why we're sitting here with this one guy they targeted from the beginning.
Well, 20 years doing this, 20 plus years doing this in courts of law, I'll tell you one thing, it's the oldest trick in the book in terms of if you got some really bad evidence against you, and there seems to be some holes in the investigation, which there's always going to be. In any investigation, law enforcement does the very best that they can. They're going to try to get everything, processed, but there's always going to be gaps. And when the defense starts picking it apart, ultimately they're going to find some holes. When you get to the defense's case in chief and they put one guy on, you have to weigh that with respect to, this attack on law enforcement's lack of investigation. And there was some, there's no question about it. Does that change the fact that the way that it presents itself, this case, that it appears to me at least that Melly is the one who did this. I mean, at some point, law enforcement doesn't have to continue on what I would consider to be a wild goose chase if they believe that they have the perpetrator. And I think that they believed that they had the perpetrator, and they based that basically on the forensic evidence and common sense to a certain extent and video evidence. So, at the end of the day, look, I know that the defense was doing what they had to do with respect to kind of attacking the investigation. But whether or not it's going to resonate with the jury is yet to be seen.
Yeah, and the defense, I think, was just kind of cocky in thinking we can get away with just this one alibi witness. We're not even going to refute the expert testimony that we thought they would. It's kind of a gutsy move. So, we'll find out soon enough whether it pays off. Jennifer, let me get the law enforcement perspective here. You're a former FBI special agent. Got a couple of FBI friends. I asked them, why are you a special agent? Why aren't they just normal agents? And then how come everybody's a special agent? Anyway, what's your take on the investigation in this case?
I think the case is very strong. I think Bob made an argument that I would make in terms of trying to poke holes in the investigation when you can't poke holes in the facts. And the facts here are just too strong. The forensics are too strong. The admission is too strong. And I thought it was interesting that he even brought up motive when the prosecution doesn't have to prove a motive. Juries like to hear a motive. But that's another indication to me when you kind of go down that rabbit hole. Certainly we've seen stranger things than a situation like this with maybe some things behind in the back that we don't know about that caused this individual to commit this crime.
Do you think, let me ask you a follow-up, do you think in that 2-hour window, that period between 2:17 in the morning when they left the studio and the 4:30, 4:40 when the two dead men were taken to the hospital, did the prosecution do enough to fill in that roadmap for us?
It could have been filled in better, but it's hard to fill in a lot of those gaps because we just don't have, or they did not have the facts to really back. But I think that at the end of the day, the strength of the other portions of facts they do have are going to far outweigh the few gaps they have in that time frame.
Okay, well, the jury will be the ultimate decider of those facts. And again, closing arguments beginning tomorrow at 10 o'clock. We'll have those for you here. They will begin deliberations, and then they're sequestered. So that can be quite the motivator. Speaking of motivation, we will keep you posted as this thing unfolds. Coming up here in just a moment, we're going to bring you up to speed on the New Mexico shooting that took place during the filming of Rust. Alec Baldwin no longer a defendant, but Hannah Gutierrez-Reed is. New charges against her. She appeared in court today. We'll talk about it after this. back to Law and Crime. I'm Michael Bryant. This will be a name you probably remember. You're thinking, what's that name? It sounds familiar. Hannah Gutierrez-Reed. Yeah, she was the DP, the director of photography for the movie Rust, where the shooting took place on the set back in October of 2021. She had a court appearance today. This is very interesting, I think. New charges have been filed. She's already looking at involuntary manslaughter, but new charges have been filed for tampering with evidence. And it has to do with the use of, or the hiding the use of drugs, because they are basically saying that she was, under the effects of alcohol and booze and maybe drugs, and that's why she loaded the gun with a live round, handed it to Alec Baldwin, who of course has now had charges against him dismissed, but he was holding the gun when it allegedly misfired. So now he's out of the mix. Her case is going forward, and these new charges are really just very interesting in light of what this case is about. They truly support what the prosecution's argument is going to be, and that is that she was somehow altered under the influence and made the mistake that she did, leading to the death of Helena Hutchins. So what about that court appearance? Let's take a look.
Provide the offenses charge and the exposure, and then I will do the advice.
Yes, Your Honor. Ms. Gutierrez-Reed is charged in count 1 with involuntary manslaughter happening on or about October 21st, 2021. And the unlawful act is negligent use of a deadly weapon, and that's contrary to 30-7-4A3. This count and the alternative count carries a maximum possible penalty of 18 months in the Department of Corrections. So the alternative count for count 1 is involuntary manslaughter happening on or about October 21st, 2021. The unlawful act is obviously handling a firearm without due caution and circumspection. And that is contrary to 30-2-3B. Count 2, Ms. Gutierrez-Reed is charged with tampering with evidence happening on or about October 21st, 2021, contrary to 30-22-5, and that count is a 4th-degree felony carrying a maximum possible penalty of 18 months in the Department of Corrections.
All right, thank you. You also have the right to release or the possibility of pretrial detention. We've already addressed that. You have the right to trial by jury. You have the right to assistance of counsel at every stage of the proceedings. You have the right to representation by an attorney at state expense. You have the right to remain silent and that any statement made by you may be used against you. And you also have the right to a preliminary examination. And that completes the advice of rights for the felony first appearance. Is there anything with respect to this, counsel?
Your Honor, in terms of Ms. Gutierrez-Reed's conditions of release, I know that at her first felony first appearance, the court permitted her to continue to possess firearms based on some, I'm sure, very legitimate threats that she was receiving. I now do have a fair amount of evidence that Ms. Gutierrez-Reed has suffered from a significant substance abuse problem, and so my concern is that we have a person who is a substance user who is in possession of firearms. I certainly would respectfully ask the court if the court is going to continue to permit her to possess firearms, that she submit to some kind of random drug testing in the state of Arizona.
Mr. Bowles.
And Your Honor, while that would seem reasonable, we have not been provided this information. As this court knows, we've got a hearing coming up August 1st. We have not been provided any witness names. The state has sought to keep those secret. We don't have this information they're talking about, so there's nothing we can go on. We don't have a pretrial report showing any drug use. So the state wants to litigate this in secret, and we don't have the information, so I oppose this until we get that information, and I can say, okay, that's a reasonable request. But I'm asking this court to consider keeping the conditions this court had already put in place. We were not alerted to this morning either. This is...
Your Honor, I'm happy to provide the court an offer of proof. I will also point out that my motion for protective order has never been intended to prevent Mr. Bowles or his client from having the information about the witness who came forward relating to the tampering charge. My motion for protective order is simply asking the court to prevent Mr. Bowles from providing that information to the media, and Mr. Bowles will not agree to that. So he would have already had the information if he would have just agreed not to provide it to the press.
Actually,
hang on, Mr. Bowles. Would the court like an offer of proof in terms of Ms. Gutierrez-Reed's substance abuse issues?
No, I think it's an ambush to Mr. Bowles right now.
All right.
All right. Mr. Bowles?
Yes, Your Honor, I really strongly object to what was just said. That motion for protective order was filed without asking me if I wanted to have this information and would I agree not to provide this to anybody. That was never asked of me. This was just filed, and this was filed as we're not giving it out. We're not going to provide it until, because Mr. Bowles is going to run to the media. Well, everybody's going to know as of the prelim who any witnesses are. So that's not true. That's absolutely not true. And we just responded to that motion yesterday.
Your Honor,
right, I'm going to, just a minute, I'm going to rule on the order setting conditions of release, okay? I do not have any information before me today, and I don't think Mr. Bowles has it either, so that he can adequately respond. Typically, it's a motion for reconsideration of conditions of release that needs to come before the court if you want to change those conditions. The information that is from 2021, I don't know who or whatever would have current information with respect to Ms. Is it just Gutierrez or is it Gutierrez-Reed? I've been calling you both. You're on mute.
Gutierrez.
Okay.
Ana Gutierrez.
Okay, so Ms. Gutierrez, I don't have any information other than the allegations from 2021 at that time. So I'm denying the oral motion to modify conditions of release. With respect to these others, we have a hearing on this. If this is news to you, Mr. Bowles, and you want to discuss this with Ms. Morrissey as far as those conditions, certainly I invite you to do that. That is August 1. I invited you to do July 27th, but you did not want that date. So it's August 1, which is pretty close to the preliminary exam. And remember, I'm not moving that preliminary exam. Okay?
Yes, Your Honor.
All right. And we're going to do that on Google, the August 1. Okay. Anything else before the court?
No, Your Honor.
No, Your Honor.
Okay. I will see you August 1 on Google. Thank you. All right. You're in recess.
Okay, just a hint, perhaps, of the back room activities between these two attorneys. Sounds like ambush, I think is the word the judge used. This was an attempt, among other things, by the prosecution to kind of hamstring the defendant, and we saw her pop up there just briefly. Hannah Gutierrez, I'm dropping the read. She seems to be Hannah Gutierrez, based on some alleged drug use and her being able to handle firearms. Interesting, and it's going to get more interesting with another hearing coming up in August. Bob Mata is here, Jennifer Coffindaffer. Let me start with you, Bob. What do you think about this new charge, which, as I understand it, is kind of a buttressing charge? It's kind of used to support their involuntary manslaughter suggestion that she was out of sorts due to drugs the day of this shooting.
I think probably what happened is that the witness, and it sounds like they got the information from a witness, that somebody basically, for lack of a better term, was a whistleblower with respect to what was going on at the set. And I think that, and I sit here having no idea when that happened. I mean, it could have been last week. It doesn't necessarily mean that they've been sitting on this information since, the time that the shooting occurred. So, I mean, obviously, as a defense attorney, I take some umbrage with the fact that the state hasn't gotten any discovery over to the defense with respect to this new charge. So from that perspective, I kind of understand the back and the forth that we just saw there. And to be honest with you, it happens in every case. That is just, everything that happens leading up to trial is where most of the battle is fought in terms of what's going to be admissible, fighting charges that are filed, motions to suppress, motions to quash. So, we never see that because we focus on the trials, but this is, like I always say, this is where the real battles are fought, because it's all dealing with admissibility of evidence and what charges are going to make it all the way to trial. So, I thought it was a kind of a neat little peek behind the curtain, because I'm always saying that we should be broadcasting any of the kind of motions that they put up, because they're fascinating.
Yeah, and sometimes they're dispositive. If it's a serious enough motion in limine that keeps something out, can affect the case either way. Jennifer, again, this whole substance abuse issue, which has been talked about, I was a little surprised to see an additional charge brought on that front. Can't you just, with the involuntary manslaughter charge that's pending, and there are two because there are alternative theories, and only one person passed, Helena Hutchins, can't you just use that information when you're putting on your case to prove involuntary manslaughter?
Yeah, of course. I think a lot of people wonder how in the world this woman made such a colossal error to load a gun with live rounds on a movie set. How did they ever even get on the set? And so this really helps the prosecution, because it gives the jurors a reason why this colossal mistake would be made. This case has bothered me from the inception. Alec Baldwin was initially charged. I cannot believe they ended up dropping those charges. I know it's without prejudice. I hope that's relooked at. For both of these individuals to only be facing, Alec Baldwin nothing, and Ms. Gutierrez to be facing 18 months for the loss of life because of a absolutely monumental error is just so bothersome. She deserves better than that.
Yeah, you mean Helena Hutchins. Yeah, it was a deadly mistake, and I think you're right. I think it is getting sort of a, well, it's too bad that happened. Somebody's going to be held responsible, but not so much. I mean, 18 months just doesn't sound like a whole heck of a lot for taking someone's life, either directly or indirectly. We will continue to follow this, of course. Again, in August, they have another hearing, and then a preliminary hearing, which is apparently taking place soon after this next hearing, August 1st. So stay where you are with that material, because we will keep you posted as it continues to evolve. We'll go back to the Florida case after a quick break here. Jamell Demons, he is going to be sitting there tomorrow listening to closing arguments for and against him. We'll come right back. back, continuing our coverage of the double murder trial of YNW Melly. This is a Broward County case. They're dark today, closing arguments tomorrow morning, so gives us an opportunity to kind of hash over the state's case. And that brings me to the crime scene reconstruction expert, Sergeant Christopher Williams. This is the guy, when we thought the prosecution case was faltering, this guy really kind of brought it back to life. He did really a pretty good job. He's there to confirm that the shots were fired from inside the vehicle. This was no drive-by. Come on. So let's look at some of that testimony.
So Mr. Williams was not even aware he was about to be shot. When Mr. Williams was shot, Mr. Thomas puts up his hands and is shot, and then is shot again. Okay. There's no time for anybody to switch a firearm. If there were, I believe one of those individuals would be alive. There's no time to switch. It was a very, a rather rapid event of firing.
Okay. Can you say the length of time between the fatal shots and then the staged drive-by shots later on?
It was enough time for the heart to stop beating, for there to be no circulation due to the wounds that I examined from the medical examiner's office. None of the wounds have any blood in them, which tells me that they're all ante-mortem wounds. So the time was long enough for the heart to stop beating.
Okay. Is there scientific or medical testing to recreate that in any way, shape, or form?
Yes, it's knowledge. I'm sure the medical examiner could say the same thing.
So in terms of, it's nothing that can be recreated with a live human?
Correct.
In terms of the number of shots, you said 17 outside the car. How many rounds were fired inside of the car?
3.
And can you exclude the shots to the head for Mr. Williams and Mr. Thomas as coming from outside of the car?
Yes.
How can you tell the ladies and gentlemen of this jury that, for example, shot that was marked as H in the here, let's go to 6755. How can you tell the ladies and gentlemen of the jury that shot H is not the one that wound up in the face of Mr. Thomas?
Because Mr. Thomas is already crumpling at this point, and he is actually he's in the clear, if you will, of site H.
How can you tell the ladies and gentlemen of the jury that site H is not the shot to the back of the head of Anthony Williams?
Because site H continues and strikes Anthony Williams in the shoulder.
In terms of site K, the one that goes completely across the car, how can you tell that no one was sitting in the rear driver's side seat when that bullet came through the car?
It would have hit their legs.
Was there any sign of blood or anything on that seat?
There were signs of blood on the seat, yes.
So there's some graphic reminder that these were like executions in this car, according to the prosecution. And this expert witness, who I think is pretty good, I think he was kind of unflappable, especially on cross. Bob Mata is here. He is the host of Defense Diaries, and Jennifer Coffindaffer, former special agent with the FBI. So Bob, this really was, to me, a high point at that time, for sure, of the prosecution's case against Mr. Demons. And we thought, well, man, we can't wait to see the defense counter this expert with their own, and then we didn't. Was that a mistake by the defense?
I think that the problem for the defense is they couldn't find anybody to counter him. You can't just stick somebody up there to stick somebody up there. You've got to be able to, first of all, find an expert. And I know there's this kind of misconception that, hired guns will get up there and say anything that you need them to say. And that's not necessarily true. I've had cases where I've had very tough facts, where I've tried to get expert witnesses. And, if they're ethical, they're going to say, I can't say what you need me to say, So, and I have a feeling that they were having a real issue, because if they had an expert that was qualified and had a pretty hefty CV, I'm assuming that they would have put him on to rebut that, because like you said, it was very powerful evidence. And frankly, it was that evidence that kind of got me over the hump in terms of saying, all right, well, it seems pretty evident that, this is how it went down. And, so I am surprised, and I'm not. I am surprised that they only put one witness on, though, and basically their defense is that he cried after. like that seems to be the extent of the defense, was that he cried afterwards.
Like I said earlier, I think it was a gutsy move to just kind of say, okay, the expert's the expert, but our guy wasn't there, and here's our evidence of that with Mr. Davis. Hey, Jennifer, I want to get your take on another key witness in this trial, Danny Polo, the masked man. We heard a lot of the text message evidence from this witness. He was an undercover detective, so the mask. Let's listen to some of that testimony.
Going right above that, on October 16th of 2018 at 9:07 p.m. Could you read this message aloud, please?
Talk to me like a man, bro. We're supposed to be bloodas, not brothers, but bloodas. Just let me know what's going on, that's all. So again, using blood terminology in his language, that is just more evidence of the association or the membership to the Blood Nation.
Okay, going on to the next message, October 26, 2018, 12:42 p.m., and this is still on page 79. And I'll switch over to the digital version to make the photo bigger. Is this the picture that was sent in the text messages?
Yeah, that's the same picture.
Oh. And in these three individuals, do you recognize them?
Yes.
And who are they?
The subject in the middle is Jamell Demons, wearing the colorful outfit. The subject to the left, well, it's not.
Well, let's go by colors.
The green shirt is Juvy, that's Christopher Thomas, and the red shirt is Anthony Williams, Sakchaser.
The next message from Kirk on October 26th of 2018 that reads as what follows. If you could please publish that for the jury on October 26th, 5:27 p.m. Again, page 79, defense counsel.
So the message from Herc at 5:27 p.m. on October 26th says, "Damn bro, I'm sorry." Get closer. "Damn bro, I'm sorry for your loss. I know it's hard right now for you right now, but keep your head up. I wish I could have been there to guide you. If it's anything you need, bro, let me know. Don't hesitate to bark at me. Love you, bro, 110%.
Okay.
He was offering his guidance in reference to what had occurred.
With this witness, it almost became more about, is he going to wear the mask today? Is he going to, than his actual testimony. Remember, there was a juror that he got so upset because he was on the stand for quite a while because there it is, she had been involved in some sort of crime with a masked man, and sitting there staring at this guy hour after hour was unsettling for her. Ultimately, they took the mask off and then they just didn't show him, so the jury got to see his face and obviously hear his testimony. Jennifer, this was weird. I'm sure you've dealt with confidential informants and officers and agents that are in that weird kind of world. What's your take on how it played out in this case with this particular witness?
Well, I think certainly and I'm going to say this correctly, the balaclava, not baklava, was certainly distracting, and it almost made him look like a boogeyman. I'm not sure that was a good way to go about this. Obviously, having worked undercover in the past, it's important to keep the identity at all costs, not out in the open and in the public. I was surprised that this is how they chose to do it, as opposed to him being someplace else and just having something shrouding him. But nevertheless, I think the information was important, you know, that association was made. And so from that respect, the information got out.
Yeah, and it's kind of almost a subliminal message as well was, hey, this guy deals with gangs. That's his thing. So he's here testifying about this case. Must be some gang involvement, which we know is a key to the prosecution's argument, not just in the guilt phase, but if they get beyond that, the penalty phase, that's going to be the enhancement they're looking for, the aggravating factor to get a jury to recommend the death penalty. So, interesting stuff. Thanks for your insight on that. I knew you'd have some confidential information with informants and things that you would be used to that weird dynamic. Let's take a break here, folks. We'll come back talking more about the Melly case, closing arguments queued up for tomorrow morning, and we will be there for that. Stay where you are. Welcome back. Good to have you along. We're wrapping up our review of the Melly case down in Florida. Closing arguments will be tomorrow. There was one defense witness. Yeah, one. All of one. Adrian Davis. This guy is one of the folks who left the recording studio at the same time as the defendant on the night in question. When he took the stand, he testified that Melly got out of the Jeep. Remember, we saw him get in the Jeep, the passenger or the driver's side rear seat, and got into the red Mitsubishi, which we also see in the parking lot about halfway through the drive. A little unclear why. Some keys were involved. Anyway, he said that he found out about the shooting when he was at home, and Melly was there at the same time. Here's some of his testimony.
Did there come a time in the early morning hours that you were woken up and heard some distressing news?
Yes.
What did you hear?
That second Juvy was shot.
When you heard that, did you see Melly in the house?
Yes.
Did you see Melly how he was dressed in the house?
Yes.
What was he wearing?
Shorts and a t-shirt, I think.
Okay. Upon hearing that Sack and Juvy, and I really should use the correct names, Anthony Williams and Christopher Thomas, were shot. What did you guys do?
We were already dressed and stuff, so we just left with Fredo's house.
Was anybody upset or crying?
Yeah, we all were crying.
Was this young man crying?
Yes.
Are you sure of that?
Positive.
And where'd you go?
Fredo's house.
That would be Fredo Bang?
Yeah.
Do you know Fredo Bang's real name? Frederick Gibbons, by any chance?
Yeah, I think I've seen it.
Did there come a time after you got to the house of Fredo Bang that Cortlen Henry showed up?
Yes.
Did Cortlen Henry tell you what happened?
Yeah, he said it was a drive-by.
When Cortlen Henry arrived at Fredo Bang's house, was Melly there?
Yes.
Did you eventually leave that house?
Yes.
Approximately what time did you leave that house?
I really don't remember.
Where'd you go?
Back to Jamell's house.
Who went with you?
Me, Trayvon, Jacoby, and Fetty.
By the way, when you first learned that Anthony Williams and Christopher Thomas were shot at the house with Melly, did anyone get on their phone?
Yeah.
Did anyone have any problem locating their phone?
Yes.
Who was that?
Jamell.
Okay, there's the star defense witness, primarily because he was the only defense witness. Let's think big picture here now. Bob Motta, Jennifer Coffindaffer. Bob, put 30 seconds on the clock, please. Let me have your thoughts on this case as we go into deliberation, likely outcome. Go.
It's tough. It really is. I think ultimately, and I don't know what the jury makeup is, which always is a factor, but I think that they're going to come back with a guilty. It's a completely circumstantial case, but I think that the state did enough to get them to where they need to be, and I think that they'll come back with a guilty on it.
Okay, Jennifer, again, 30 seconds on the clock. Give me your thoughts on where we are now, what this jury is going to do with this, thoughts on sequestration, whatever.
We got a text confession. we have what I believe is irrefutable forensic evidence to show that those shots came from within the car and execution style. I think the jury's going to find him guilty. The sequestration is just going to make that verdict quicker.
All right. I definitely agree with that. I'm going to thank and excuse Bob Mata and Jennifer Coffindaffer. Thank you, folks. Always a pleasure. See you next time right here on Law and Crime. That's going to do it for me. Shameless self-promotion tonight on A&E, 10 o'clock, I Survived a Crime, a Law and Crime production and Stark Raving Media production. Good stuff about folks doing the best they can to survive some pretty scary situations in this world. That's going to do it for me, Michael Bryant. So don't forget, tomorrow, 10 a.m., we're going to have the closing arguments in this case against Jamell Demons. It is a death penalty case. It is something we've been watching it unfold. Tomorrow, the crescendo. See you here for that. Try to do the right thing. See you next time on Law and Crime.